And record.
Good morning, everyone, and thank you for joining us for eDiscovery Day. Today, our topic is AI, artificial intelligence, or attorney intelligence. And our speaker will be Tom O'Connor. Tom O'Connor is a nationally known consultant, speaker, and writer in the field of computerized litigation support systems. A New England native who graduated from the Johns Hopkins University in 1972 with a BA in political science. Tom attended law school for 1 year at the University of Notre Dame before returning to Baltimore and undertaking a career as a paralegal, specializing in complex litigation. Many years later, he earned a JD at an evening law school program. Tom's consulting experience is with both small firms and complex litigation matters, including the BP litigation in New Orleans and several current opioid MDL matters. He has also been appointed as a technical consultant by various federal and state courts on cases dealing with large amounts of electronic evidence and specializes in negotiating ESI exchange protocols. A frequent lecturer about legal technology, Tom teaches CLE and law school courses nationwide and is also a prolific writer. He was a co-author of the 2006 award-winning article, In Katrina's Wake, which covered recovery efforts in the legal community of post-Katrina New Orleans, in which he participated. He was also the author of the second, third, and fourth editions of The Automated Law Firm, a guide to computer systems and software, published by Aspen Law and Business, as well as The Lawyer's Guide to Summation and eDiscovery for Small Cases, both published by the ABA. Tom has been awarded numerous professional accolades, including the inaugural Betsy Ann Reynolds Award for Excellence in Litigation Support from the Litigation Support Leaders Conference and the inaugural Scarpetti Award for Professional Achievement from the Masters Conference. Tom currently resides down the Mississippi down in New Orleans with his wife, legal marketing maven Gail O'Connor, and their son Seamus, the captain of the current Kings of Crescent City Skateboard Championship team. Tom, thank you for being here today. Look forward to your words of wisdom today.
Thanks, Gail. Appreciate the kind words. So let's talk about artificial intelligence. As Gail mentioned, and as your screen shows you, I am of the opinion that AI, the acronym AI, should really stand for attorney intelligence and not artificial intelligence. And I have two reasons for that. The first is not to demean in any way the scope of artificial intelligence. In fact, you'll see as we go through this that scope is extremely wide and covers an enormous amount of activity, both legal and non-legal. And I highly respect all of the efforts that are there. The other general reason is that we really, in talking about this field, don't have a lot of definition. Our use of the phrase is widespread. Perhaps our understanding of the phrase is not so widespread, and we should return to attorneys being in charge of what's going on instead of ceding that authority, if you will, to computers that we perhaps do not understand. I would say that, honestly, in today's legal technology market, there's three big buzzwords right now that we hear all the time. Cybersecurity, privacy, especially with regards to things like the GDPR and the about to be released California privacy regulations, and AI. Well, if you take the first two, cybersecurity and privacy, people understand what we're talking about. It's pretty clear what the definitions are, what the problems are, and what the potential solutions are. However, with AI, I don't think we have any of that sense of clarity. So what we really want to do is dive into that and see what we can discuss. So as a general agenda, I want to talk about what AI is, how it's used in the general usage that is in the general scientific terms that translate into non-legal activities, and then take a look at some of the legal activities where AI is being used, and then discuss what's the best way to use AI in the legal world. And perhaps I should move my face out of the way of the screen so people can read what's being said up there. So what is AI? Perhaps the first and best known use of the phrase came in 1950 with what is now known as the Turing test. Alan Turing was a mathematician, a computer scientist, a logician, a crypto analyst. He worked in a number of different fields, and he started working in the early days of computer science. And he was interested about where does the definition of intelligence begin and end? How do we know if a computer is in fact intelligence? And so he developed the Turing test, which basically says that a machine's ability to exhibit intelligent behavior that is equivalent to or indistinguishable from that of a human. That is, if the person interfacing with the computer, and remember, we're talking 1950, so we're basically talking written responses to questions or scenarios that have been typed into a computer, perhaps even put into a computer via some sort of a punch card system to set up a scenario. But if the individual who's interfacing with the computer cannot reliably tell from the responses whether he or she is having a discussion with the computer or a person, then the machine is said to have passed the Turing test. What's really important here is it's not important that the machine get the correct answer to the question. That is to say, it's not a classic IQ test. You're looking for specific questions. It only depends on how closely the answers it gives resemble what a human would say in the same scenario. What's interesting is for years now, different AI laboratories around not only the country but the world have been giving several Turing tests a year, and to date, no AI program has passed the Turing test. That is to say, no AI program has significantly been confused with a human being. I should say that the more current tests, the parameters have been also tightened a little bit in that now the test can only be successfully passed if the machine is mistaken for a human more than 30% of the time in its responses during a 5-minute interrogation. So they limit the time of the test and say the confusion has to exist for no less than 30% of the responses. Interestingly, some of you may have seen some of the advertisements on TV for the Watson computer system from IBM, which is their current AI model or platform, I really should say. And one of those advertisements featured Bob Dylan, the famous singer, who has a very sort of flat, monotone, Midwestern, twangy nasal. Bob comes from way upstate Minnesota. In working on the computer, at some point, recordings were being made and played back for different people to listen to what some of the scripts were. And apparently, some of the people who were listening to the different voices and the different recordings thought that Bob Dylan's voice was that of the computer, sort of a reverse Turing test. It was unclear who the computer really was. So next in the development of AI, 1956, John McCarthy's workshop at Dartmouth, and this is Dartmouth College in Hanover, New Hampshire, not Dartmouth in England. This was a workshop that went on for about 6 to 8 weeks, featured a variety of different people, some who came and left for varying lengths of time, and started talking about not only the Turing test, but other things that were being developed. And this was really, or it is considered to be the place where the field of AI really was fleshed out and made a specific area of study. By the 1960s, we had the study and design of what were called intelligent agents. We'll talk about these in a little bit because you may be more familiar with some of these under what in legal we call expert systems. And then in the 80s, we had Edward, I hope I'm pronouncing his name right, Feigenbaum, and his further development of expert systems at the Stanford Heuristic Programming Project, which I believe is still active. 1990s chess systems. We're going to talk a little bit about chess systems because playing chess is generally regarded as also a true measure of human intelligence. And some interesting things popped up in the development of some of the chess systems. And of course, by the 2000s, we had the rise of robotics, or as some of us like to call it, Skynet. So what are some of the uses of AI? This chart is one I grabbed off of, and I'll have to apologize, I didn't put it on here. I forget which site I grabbed it from, but this is some scientific definition of various types of AI. The first one at the top, the very top of the list, machine learning. Of course, completely familiar to anybody who's looked at this field in legal, where we do a lot of these machine learning, predictive coding / TAR types of systems, and we have supervised and unsupervised. So some of this goes directly into what's going on in legal. Likewise, natural language processing. We have natural language systems and have had them for a long time. Companies like Lexis and West were doing natural language systems in their search engines many, many years ago. Right? Gail, do you remember exactly when the first natural language system came out? I want to say at least 15 years ago.
Oh, it was at least 15 years ago. If I really want to date myself, I would say it was more like 20 years ago.
Yeah. So the point being, uses of AI in the legal system go back quite a ways, well beyond the last several years, where
Tom, let me just preface that to say that Boolean logic was even way before that.
Oh yes, yes. That's the old traditional search systems with the and or connectors and parentheses.
Exactly.
The idea was that natural language was a use of AI to avoid having to do that. People could either type in just a natural language phrase. I'm searching for all cases involving big rocks falling out of the sky and crushing Volkswagens. And of course, more recently, that's evolved into voice systems. And we'll talk about that in a minute as well. Another one of the uses of AI, and again, these are general uses that the scientists have defined for us, are expert systems, intelligent systems as they were first called. Computer vision, which is image recognition, acquiring, processing, working with different types of images, and even more recently, things like facial recognition at airports and banks for ID systems. Of course, planning and optimization. We'll talk about this in a bit, and once again, robotics. Well, these are all very nice academic classifications. But what does this mean in real life? Where do we see AI in real life? Well, I think the biggest example, the one that we probably all have had some exposure to, is voice recognition, as I mentioned just a moment ago. Google, Alexa, Siri, Cortana, all of these different systems are very, very widespread. And we don't really think of them as AI, but these are really AI systems. And of course, that's expanded into things like smart cars and GPS and interactive video games, especially with a combination with some of the optical systems and the virtual reality systems that we have now. But it can be something as simple as a Roomba, right? A device that has rudimentary instructions in it about how to proceed going around a room and not running over things, but recoiling when it touches something and cleaning the room at the same time. The ones that are really interesting to me are some of the music systems like Spotify and Pandora. I'm always amazed when I'm walking someplace with Gail and we get on an elevator or we're in a lobby and we hear a song being played on an intercom system, and I say, "Oh, what's that?" Gail will take out her cell phone, open up is it Shazam?
Shazam.
Yeah, and she holds the phone up, and it not only recognizes the song, it will identify the song and the artist in the vast majority of cases, but it will then add it to a Spotify playlist that she has on her phone. Again, something that many of you have probably encountered or even used, but we don't think of it as AI. It is. Pandora, of course, where you can type in or use your voice system to say, find me, I don't know, something obscure, an obscure song. Find me 2,000 Light Years from Home by the Rolling Stones, which was on a very obscure album of theirs many years ago. And it will go out and find it and play it for you. And then you can say, find more like this. And it will start to build a playlist in Pandora of songs like this. I use it all the time when I'm sitting here working. I have an Amazon Music playlist going, same thing, where I found songs by Thelonious Monk, and I'm playing jazz in the background, and it will offer me choices. Do you want to add this? Do you want to add that? So on and so forth. John Tredenick, who many of you may know, is the founder of the Catalyst Systems eDiscovery software company. He's now moved on to his own think tank, if you will, called, John, please excuse me if I get this wrong, but I believe it's called Merlin Legal Systems, where he's using open source software to explore some solutions for eDiscovery for lawyers. But John made note many times of how some of the predictive coding systems that attorneys use in eDiscovery are much like Pandora with their find more like this or find similar solutions that then shoot the results back to the attorney for a thumbs up or a thumb down. And then finally, we've got Deep Blue. I talked about computer systems. And this to me is fascinating. It's probably not as equally as fascinating to everyone in the audience, so please bear with me. There have been a number of chess programs built or attempted to be built using computers going back to the days of Alan Turing. Mr. Turing he did write a program called Turochamp, which was one of the very earliest chess playing programs. Unfortunately, the algorithms were too complex. Algorithms are the underlying computer, I don't want to say programs because they're not quite as complex as a complete program, but the formula, if you will, that run things. And we're going to talk more about algorithms in a bit. But the algorithms he wrote to perform this chess program, and again, chess is something that people use as a way of determining intelligence in many cases, and the way you play chess, or the way grandmasters play chess, is to play all the games they possibly can at a very early age and start thinking about how to retrieve those earlier games by other grandmasters when they're contemplating a move. Obviously, because there's a fixed number of squares and a fixed number of pieces on the board, when any situation presents itself, there's only a fixed number of responses. Those can be hundreds of thousands, and so it can be completely complex. Mr. Turing could not write a series of algorithms that could be performed on the computers of his day. So the program never actually ran on a computer. Much later, up into the 60s and 70s, people took that program, updated it, and put it on some Unix systems, and then trained computers to work in it. By 2012, Gary Kasparov, who's pictured here in a befuddled moment playing Deep Blue, the IBM computer system. We'll talk about that in a second. But in 2012, Kasparov played the Turochamp program that had been updated, yeah, he won in 16 moves. The feeling was that it was still not really a good job of being updated onto the system. But Mr. Kasparov's really better known for his his conflicts with the Deep Blue system from IBM. It was a chess playing system that became famous for being the first one to win first a chess game by defeating Mr. Kasparov, and then later in a rematch, it beat him in an entire match. It's interesting for several reasons. The rules and the setup are I think bear a little bit of scrutiny. Mr. Kasparov, of course, was not just a grandmaster, but was the reigning world champion in chess at the time. So therefore, he was basically considered the best chess player in the world. Deep Blue, the IBM system, was not really a computer. It was a parallel system of an RS-6000 SP thin P2SC based system that had 30 nodes. Okay, it had 30 separate 120 megahertz P2SC microprocessors that were all linked together. And each one of those nodes had 480 special purpose VLSI chess chips. So in essence, he was not playing a computer. He was playing at the bare minimum 30 computers, each of which had 480 individual chess program chips on their systems. It was capable of evaluating. Remember, I talked about how a human would think about prior games he had seen and try to retrieve those in his or her memory. The computer could evaluate 200 million possible moves per second. So it seemed like the deck was a little stacked against Mr. Kasparov from the beginning. In addition, the rules of the tournament were that, first of all, unlike a human versus a human tournament, where each of the people would go back and look up all of the games that his or her opponent had played in the past. They're recorded by the various chess systems worldwide, and earlier were available in books, now of course available online. But they would study all the games that this person had played, as well as other grandmasters, so that there are certain ways of proceeding with openings and defenses. And everybody knows those sorts of openings and defenses and certain moves in certain positions. Mr. Kasparov asked for the memory logs, the computer logs, if you will, of all the games that Deep Blue had played against other grandmasters. That is to say, it had been playing them going on their pre-recorded instructions, or a human programmer was running the plays of another grandmaster. But he basically asked for what he would have gotten if it was a human he was playing, and IBM refused to give it to him. In addition, Mr. Kasparov had insisted that there could be no human intervention on the system once it had been programmed. It was later agreed upon that the programmers could adjust the program based on what had happened each day at the end of each day. The idea being that Kasparov, if he was playing a human, would have considered how that person played and made adjustments in his thinking. Therefore, it was only fair for the computer programmers to do the same with the computer. What wasn't clear apparently at the time was it was not just programming, but there was at least one grandmaster advising them of what to do. So some of the human intelligence or intuition or interpretation or analysis, if you will, was in fact human and was being provided each day. So first meeting between the two, February of 1996, Deep Blue won the first game. Kasparov, of course, was extremely confident that the computer would not in any way, shape, or form be able to beat him, and it won the first game, which was shocking not just to him, but to the entire world. However, Kasparov then, out of the next 5 games, won 3 and had draws in 2, and eventually beat Deep Blue. A draw counts for a half of a win. Deep Blue won the first game and had 2 draws. Kasparov won the tournament 4 games to 2. He asked for and was granted a rematch. There was some heavy upgrading that was done by the people at IBM, and the new computer was called Deeper Blue. That match commenced in 1997, and it was a 6-game rematch. After 5 games, the score was tied. The 6th game then became completely pivotal, and Kasparov made an egregious error in his opening several moves. something that he later attributed and admitted was completely based on nerves. He couldn't at that point believe that he was actually in a tie with the machine. So the computer won. Deep Blue won. Kasparov accused IBM of cheating. He said that in playing, he thought that he detected notes of intelligence, human intelligence, and or even human intuition, intuitive moves that were being made by Deep Blue, which would have meant there were humans assisting in the programming during the course of the match, which of course was against the rules I discussed earlier. This is really important for two reasons. First of all, it is those sorts of intuitive or seemingly even illogical moves that human champions are very well known for. The most famous being Bobby Fischer, the great American champion, who when playing Boris Spassky for the championship years later, at a critical point in the game, abandoned what was his normal opening move, one that he used in virtually every game that he had played for 10 years, since he was even longer, perhaps, since he was 6 or 7 years old. He always moved the pawn in front of the king first and moved it out 2 squares. Instead, he used what was called the queen's gambit and moved the queen's pawn up in an attempt to control the center couple of portions of the board with a very drastic move. In fact, he had, in all of the games, the recorded games he had played before, he had only ever used the queen's gambit twice. It completely threw Spassky off of his game, and Bobby Fischer went on to defeat him and win. So that semi-illogical sort of responses were what Kasparov claimed he was seeing, and he, of course, said that must have been humans assisting the computer. Of course, another explanation would be that perhaps the computer was learning. Perhaps it was developing some form of artificial intelligence and knew that or had learned from playing Kasparov. And remember, it had been playing Kasparov now for quite some time. Learned that, in fact, the best response was not the pre-programmed response, but to try something different, perhaps. And then more recently, of course, we have Watson, the current IBM artificial intelligence computer system, which is used for a whole host of different systems. We'll talk about some of them as we proceed here, but they also have a current computer system. I'm going to mention this again at the very end. But what about something that's a little more up to date for everyday use? Here's something that kind of hits home with those of us here in New Orleans. The person up in the upper left-hand corner there is an individual who used to play for the New Orleans Saints football team. His name is Steve Gleason, and he came from small town and went to college in Spokane, Washington. Ended up in the NFL and came here for a number of years, starting about, I don't know, 2002, 2003. The point being, he was here in 2006 when Hurricane Katrina hit. And the picture in the middle is a shot of him. He's the blur, just off the left of center in the middle there. That game was the first game played in the New Orleans Superdome after Hurricane Katrina. It was a Monday night game at the beginning of the season against the Saints' arch rival, the Atlanta Falcons, and Steve blocked a punt, which has become legendary in New Orleans folklore. He's rushing in right there to block the punt. It was recovered by another player, run in for a touchdown. The Saints won the game. It was, in fact, became part of what was known as the rebirth in New Orleans. Unfortunately, Steve retired about a year later and went on to some business ventures. But in 2011, it was revealed that he had ALS, Lou Gehrig's disease. And so he first founded a charity called No White Flags to assist other ALS victims. That's the picture in the upper right, along with several of his friends and familiar faces in New Orleans. That's Sean Payton, the coach of the Saints, on the left, and Drew Brees, the quarterback of the Saints, on the right, both good friends of Steve's. And in the lower left, you'll see as his disease progressed and he was confined to a wheelchair, the Saints themselves erected a statue of the punt being blocked in front of the Superdome. But Steve, because of the progression of the disease, the digression of the disease, if you will, became very active in further efforts through the No White Flags to assist people who had the same disease, and then began working heavily with Microsoft. And so some of the computer systems, the AI systems we mentioned earlier, voice recognition, sound recognition, facial recognition, he has become really a prime mover in getting Microsoft to come up with new systems to assist people in the same situation. And the large picture on the bottom right is he in his one iteration of his current wheelchair. You'll notice he has a tracheotomy and is unable to speak now, but is not using what was a very common method of interfacing with computers at the time, which was some sort of a breath stick to use through a directed straw-like mechanism, breathing onto a computer screen letters so that you could communicate. In fact, he's come up, or he and Microsoft have come up with a much more sophisticated way of doing that and communicating. You can see some of the things on his hands, some of the devices on his hands. He, like I said, he's just become the forefront of this. That's his son, Rivers, sitting on his lap, and his wife down there to his lower left, the right of our screen. Steve has become a legend here because of his promotion of AI technology for something that is of immediate and personal use to, I would wager to say, hundreds of thousands of people around not just this country, but the world. Well, that's all great, but what about our subject? What about AI in legal? It's become pretty common, as I mentioned. We hear about this every day. That is a mainstay component of the legal profession. In fact, just this week, this morning, I saw an article on law.com that discussed AI and a challenge to facial recognition systems, I believe, in the state of Oregon, in one of their state agencies that had been raised. Yesterday, there was a great article on Techno Lawyer. Any of you who are Techno Lawyer subscribers probably saw it, or it'll be in your mailbox and you can take a look at it. If not, you can go to Techno Lawyer and take a look. And it's an extensive article written by the folks at West about some of their usage in legal of AI. And I'm going to quote a couple of things that they say as we talk a little bit more about this. But the point is, there are systems with AI usages that are being reported virtually every day. The thing that's really interesting, though, to me, is a really deep dive report that went into the underlying portions of some of this technology, and that is something we mentioned a moment ago: algorithms. Algorithms are the basis for much AI technology, and a really intense study was done and presented in a white paper 2 years ago at the annual conference of the AALL, the American Association of Law Librarians. And they were the first ones that I recall really dealing with this subject. I'll have the URL for that, the citation for that at the end of this, along with some other references that you can get to. It's a great paper, and often overlooked. Law librarians are a mainstay of legal technology in the firms in which they're employed, because they're called upon to work with so much technology, even in the limited field of search and retrieval of legal resources. In fact, it's a rather well-known saying, and Gail herself, at the beginning of her legal career, was a law librarian for the large American firm Brobeck, Flager, and Harrison. She was a librarian in their San Diego office for a number of years. And the well-known saying was, if you absolutely positively need to have an answer for something today, ask a law librarian. This discussion of algorithms was fascinating. One of the things they did was mention, in fact, it was a quote from Mike Don, who was then the senior vice president for Westlaw Product Management. at Thomson Reuters, in which he stated that all of our algorithms are created by humans. Well, that's the telling point. We think of these types of systems, these AI type systems, as being computer driven and therefore somehow in our minds infallible. But in fact, the underlying technology, the underlying algorithms are written by humans. Why is that critical? Because the biases and assumptions that get coded into each assumption, into each system, and have implications for the results they deliver are, in fact, human biases and assumptions. And what did the AALL survey find? Astonishingly, they did some basic searches in, I believe, 7 or 8 different search engines, including, but not restricted to, Lexis and Westlaw, and found that not only from system to system, but sometimes even in the same system, the results were not the same. You would think that if you ran a search in computer systems, even if they're from different companies, for show me all the cases where big rocks fall out of the sky and crush Volkswagens, that they would be either the identical or very, very close to identical. And in fact, they were not. There were significant differences and variations. Even more astonishing, when the librarians went back a year later and ran the same searches, they got different results. Well, of course, they got different results from new cases that had come in. But when they looked at the cases from the date they ran the first search going back in the new search, sometimes the results were different as well. Not all of the cases that had been displayed from the first search were showing in the second search, which would indicate to them that the algorithms had changed, had been updated, quote unquote, but we're getting you different results. So a person looking for a series of cases going back to, let's say, 20 years about big rocks falling out of the sky and crushing Volkswagens, if that person did the search now, as compared to somebody who did the search 2 or 3 years ago, they would not necessarily get the same results. Astonishing, and I highly recommend that you take a look at that report. As I said, I'll give you the citations of that at the end. And that is a microcosm of what occurs, because AI in legal is used in a number of different scenarios. The building of contracts, what we used to call in the early days document assembly. Due diligence, searching for, as I just mentioned, case law, decisions, conflicts of interest for clients, intellectual property cases, of course, my field, eDiscovery, e-billing, case management, just general analytics, crunching through all the documents to look for trends or some sort of policies or procedures that were being violated in email systems or even in general documents that were being saved. Contract reviews, as well as prediction technology. This is an interesting field where people are looking at decisions. And again, remember how finding decisions is very key to determine if certain judges are going to rule certain ways. Another one of the references that I'll give you at the end is from a law school professor, Daniel Katz, at the Chicago Kent School of Law, who's done a lot of research in that area and has talked about it before. So the point is, AI is not just something that we use in eDiscovery. It's something that's being used in many different fields, in many different ways, and it's important to be aware of that. So what are a couple of examples? What are a couple of real life examples? Well, ROS is a computer system that was built by an attorney named Andrew Arruda. It's built on IBM Watson. Remember, we discussed Watson before. And it's Andrew's very forthright in stating this is an AI system that he calls in some of his information the first artificially intelligent lawyer. And he talks about its ability to quote, help lawyers serving on the front lines get better results for their clients and become better lawyers in the process. How? Well, according to a TED talk that he's done on several occasions, a quote again, Ross can read over 1 million pages of law in a second, finding the exact passages that lawyers need, end quote. Obviously, to the first point on the list here, he's very interested in legal research and or due diligence and using a system like this that can be extremely fast and extremely accurate in pulling those results. Likewise, it can review documents and contracts and help you, as I mentioned on the previous screen, predict legal outcomes. Interestingly, Ross has gone in the last 6 months or so to expand a little bit. He has partnerships now with Clio, which is an online case management system. And I believe just in the last several days announced a partnership with FastCase, another online system. The point being, he's trying to give access to lots of different data sets to expand the scope, especially of number one on this list. And using artificial intelligence to comb through data sets that are in fields, not as the Clio interface shows, not just part of legal research, but other aspects of the legal media, the legal environment, if you will. I have a citation to some information about the Ross system that I'll provide you at the end also. Please, I should hasten to add, I'm not endorsing any of the products I just mentioned. I'm just talking about them as examples of a very, very widespread use of AI that cuts across several different areas of legal information technology. And then we have what are called legal expert systems. Remember, we talked about the intelligent systems in non-legal and how that pervades or blows out into legal expert systems, which can be used on a host of different areas or topics. Excuse me while I refresh myself here. So what is an expert system? Well, an expert system emulates the decision making of a human. It's going to allow, as you can see on the far left, a non-expert user through an interface to make a query and get some, if you will, advice back. Unlike straight search engines looking for a specific case, a specific phrase, a specific judge, it's designed to help solve complex problems by using some form of reasoning. And it doesn't follow the procedures of a developer, that is an algorithm per se, but rather information from an expert, what we would call in legal domain knowledge. And if you refer back to that Techno Lawyer article that I mentioned, the West people talk an awful lot about using systems, their expert systems, using domain experience. So you get the knowledge from an expert, which is used to help build a knowledge base, which is then queried after the non-expert user gets involved by what is called an inference engine. An inference engine interprets and evaluates the facts in the knowledge base in order to provide an answer. And this could involve classification, diagnosis, monitoring, design, scheduling. It allows the expert system to draw deductions from the rules in the knowledge base that were set up by the domain expert, or what we in legal often call an SME, a subject matter expert. A good non-legal example of this is a computer system that Watson put into play at the Anderson Cancer Center in Houston. And I actually, it's funny, our good friend Browning Marian was treated there several times when he was going through his struggle with cancer. And he said that he started talking to some of the folks in there when he learned that they had an expert system that was designed by Watson. What was interesting was that the people said when it first was installed, and I want to say that was perhaps 10 years ago. Please don't hold me to that, but they've had it for a while. But it made, quote unquote, a lot of mistakes. It came back answers that were not so on point. In fact, one individual, and there was an article, and again, I'm sorry, but I forget where this came up, but one assistant professor in the leukemia department said you could put in a diagnosis and it would return a random treatment that wasn't necessarily on point. and I'm sorry, my notes indicate it's actually more recent than that. This discussion came about in 2015, so fairly recently. Now this individual said the system still makes plenty of mistakes, but sometimes it suggests a treatment to which his reaction is, oh my goodness, why didn't I think of that? And it does that in minutes, not days or hours. So again, the speed of computers is one of the powers of computers. In this case, though, expert systems rely on the knowledge of humans and that interface, if you will, the power, the best of both, speed of the computer, knowledge of the human in an expert system produce the results. Well, that's all well and good, but at the same time, we clearly have a number of AI fears in the legal space. Mike Quateraro, the current head of ACEDS, the organization, the Barbary organization, is that designs a CEDS test for certification or qualifications as an expert in eDiscovery. Mike had a question and answer scenario that he wrote on Above the Law about a week ago. He said, with all this talk about technology and expert systems and TAR and predictive coding, why is plain old search, even what Gail mentioned a few moments ago, Boolean search, why is that still the number one choice by an enormous margin of people? What is the fear? I, in response to that, posted, and I don't think that is particularly a fear. I think that is because search is the one technology that is taught in law schools. Not even really taught, but law students are, of course, given free accounts on Lexis or West or whatever, and then can use those for the duration of their law school experience and become adept at search technology. It's the one technological skill they learn while they're in law school. Therefore, they are prone to continue to use it. That hardly seems to be a big deal to me. Not surprising at all. But what about the other fears? What about the fears of technology that have to do with how it's being used? Some of the traits of AI systems, and these go back to the legal definitions that I mentioned at the beginning. When you ask computer scientists, they say, well, here's what we're trying to do. We're trying to impart to these computer systems, to these computers, deduction and reasoning and knowledge and interpretation, planning and learning skills, perception and social intelligence, something well to be admired and yearned for humans as well as computers, creativity and even general intelligence. Well, of course, especially first-year associates are going to be afraid of that because much of the work that is done at the entry level by these AI systems now, especially in the eDiscovery phase, are functions that are done very often by first-year associates. And in fact, an analysis in a Deloitte report earlier this year in Legal Insider said that technology has already contributed to the loss of more than 31,000 jobs in the legal sector. It went on to say, however, that those tend to be basic jobs. At the same time, computerization, again, according to the report, has led to an overall increase of approximately 80,000 jobs, which are higher skilled and better paid. So the point is clear. Learn the technology, learn to use the technology to not only get over your fear, but adapt yourself to the skills that the computer systems are designed to do above and beyond entry-level basic searching, finding privileged documents, deciding if something should be included for review or not for review. Deloitte predicted in that same report that over 100,000 jobs will be automated in the legal space by 2036, but much like the 80,000 jobs added while 31,000 are cut, they expect a net increase in the number of legal technology jobs, but that they will require some advanced skills. So don't be fearful, get some training, find out how these systems work, make yourself the go-to person in your firm. What's the other fear? Well, the other fear, of course, is I know we've had some issues here, Hal, and I know I've made some mistakes. There is just a general fear of computers. I call this a black box fear. We don't understand what computer systems are, so we're fearful of them. Again, this is reinforced by movies like 2001, Minority Report with its analysis of precognition analysis of people and what they were going to do. There's a sense that computers are somehow going to be used against us or will work against us, and the next thing you know, we'll be locked out of the spaceship and floating around in space in our spacesuit to slowly to have a lingering, ghastly death by lack of oxygen. That's not going to happen. As I mentioned in that Deloitte report, jobs are coming, and we need to have the skills to use them. And why is that? It's because these are tools. Okay, we've lost focus on the point I was making at the beginning: attorney intelligence versus artificial intelligence. People get spoiled by the easy button. They hit the button and things will happen. That's not the way things work in legal. These are tools. These are one of many tools. And in fact, AI may be a big old power skill saw tool, but it still needs a master craftsperson to run it. This is a point I've made for a number of years. I quoted in a blog several years ago, fellow technologist John Martin, who's been around for a number of years, and John was fond of saying, and I quoted him as saying, "It's not the archer, it's the arrow." And here it's I have to say it's not the tool, it's the carpenter. And so that's very important. It's very important to say, what do you want to do? You have a number of different tools to do different tasks. They're going to be deployed, and you have to decide which of those you're going to do. You have these skills: domain knowledge, logical reasoning, organization, strategic, communication skills, or these are all the skills that attorneys have, right? And we use these to figure out the answers to these questions. And which of our technology tools will we use, not just for one of these individual boxes, but for all of them. Why is this important? Two reasons. First of all, because our process, this is the EDRM chart, which is probably known to anybody who's looked at legal technology in eDiscovery, which was deployed originally as a straightforward chart, which its original founders, George Socha and Tom Geldman, the project itself has now been acquired and is being run by Mary Mack and Kaylee Walstead, two names that are probably very well known to folks in legal technology. But George and Tom were careful to say, hey, this isn't a across the board, start at the left, work to your right. It's more like the chart on the right. The chart on the right is one that I helped in putting together what we call the eDiscovery Manifesto for the good folks at Digital War Room. It's on their website, and it's a circular task. These tasks, a circular wheel, if you will, of tasks, where each of these can be done. You might skip from one to another. You might go back and forth. It's iterative. It's repetitive. All right. Why is that important? Because we have ethical duties to understand how all that works. These ethical duties are not just in the United States. Okay. We have, in fact, in the U.S., the Federal Rules of Civil Procedure, which in FRCP 1 admonish us courts and attorneys to handle all matters in a manner that is just, speedy, and expensive. But in Canada, where the rules of civil procedure are administered, of course, separately by jurisdictions, both federal and provincial, 9 of the provinces and 3 in the territories in Canada are common law jurisdictions, but Quebec is a civil law jurisdiction. Their law societies say that you must emphasize the administration of justice and the community's confidence in the profession, ethical duty imposed by the law societies. And finally, in the UK, new civil procedure rules went into effect in 1999, and Rule 1.1. These rules are a new procedural code with the overriding objective of enabling the court to deal with cases justly and at a proportionate cost. There is an ethical duty in the UK to provide quality, not quantity. In addition, we have a second ethical duty, which has popped up more recently. That is the duty of technical competence. We are admonished by bar associations, and 38 of the states have a specific rule. California actually has a specific opinion that applied only to eDiscovery matters, but which basically says, and it's the tone that was set for the rest of the states, that you have two choices: learn this information yourself or engage somebody who does. That can be a co-counsel, or it can be an outside consultant or vendor who has expertise in this area. This, again, is not just a US phenomenon. I'm happy to report that just within the last week, Canada also has imposed through its law societies a duty of technical competence. So we understand that this is something that happens around the world. When will this be accepted then? Of course, I love this phrase from the movie Philadelphia, where Denzel says, explain this to me like a 4-year-old. Herb Roitblatt, another well-known computer technologist and player in our space, said that consumerization of technology will lead to acceptance of AI. He said that to me at the Georgetown Advanced eDiscovery Institute several weeks ago, and he was basically saying, we need another Deep Blue. We need another big win by a computer system that is understood by people in the consumer field to be something that is AI that is easily adaptable to us. He said he thinks that's what the next big move will be. These are the resources I promised you. These are going to be made available. Gail is going to post these on my particular website, which is, well, it's actually the YouTube channel, the eDiscovery channel on YouTube. The URL is right down there. You'll be able to get this and as well. There was one quick question, Gail, if you'll bear with me. I had a direct message. Somebody said, how do I find out who people are I can engage?
Sure, and I just want to throw out to please make note of that eDiscovery channel URL there at the bottom so that they have that to be able to access the slide deck.
Yes, the video and the slide deck will be available at that site. It's, again, on YouTube. It's the eDiscovery channel, which has a number of other videos that we've done. The Office 365 series I did with Rocky Messing from Microsoft, as well as some from the two other gracious gentlemen in the center there. On the left, that's Judge John Faciola, and on the right, or in the center, of course, is Greg Ball. How do you find somebody who knows how to do this? Let me just say quickly, ask around, look for companies, vendors who have worked in this space. Judge Peck from the Southern District of New York, who's now, he's retired from the bench and he's with the law firm of DLA Piper. Judge Andrew Peck, he used to like to say, bring your geek to court to explain these things to me. I think he was using the federal rules as the basis for that. But now we have a technical admonition to do that. Get a geek. You need to get a geek. Ask them to tell you what they've worked on. Ask them to discuss their cases. Ask them to give you references. Ask them to explain their algorithms and their way of working. Good vendors, good people who work in this space will not only have no problem doing that, like me, they won't be able to stop talking about it. And Gail is waving frantically at me in cyberspace to please step back. So thank you all. If you have questions, please email me, or Gail will be happy to discuss this further with you offline. Thank you, Gail.
Thank you, Tom, for your time today. Really appreciate it. Remember, go to the YouTube channel and hit the eDiscovery channel. There are similar ones to that title, but it is the eDiscovery channel where you can get a replay of this video. Thanks again, Tom, for your time today.
My pleasure. Happy to be here. Always enjoy speaking, and look forward to working with you in the future.
Thank you.